each and every student who we have here, so that we can better know each other. So today we're gonna have the first lecture within this course on feminist judgments, and for the purposes of this introductory lecture, I decided to call it "Why Feminist Judgments," because just like with human rights and gender perspective, we can ask ourselves why all of a sudden need to take a particular look on human rights from the gender perspective. Well, we have the same problem in the context of judgments and drafting of judgments and taking decisions as judges. And judges are important, and judgments are important because they're a way of delivering justice. So they're the way of integrating. Okay, I have to also close I opened my mobile phone because of you. I'm going to close it now. They are the way of delivering justice. They're a way of bringing social harmony to the society if they're done properly. If they're not done properly, then justice, judiciary doesn't perform its function properly. So this is why we need to take a look at how the judgments are delivered. How does the process of taking decisions take place? How does the judicial process in itself look like? In order to understand why there is a need to reconsider the way the judgments are drafted and to reconsider the drafting of judgments in order to take the feminist perspective into account. We talked yesterday about the deficiencies in the human rights law, that already human rights law, once again, a crown of a legal system is not perfect, and that there is that even in the human rights law, we don't ask women's question sufficiently, or the question of other people with gender specificities, differences in minorities in compared to the others. So yes, we can speak, and we do have the course on the feminist judgments, but we could also do the same kind of drill, the same kind of exercise with respect to other minorities, and asking ourselves whether the judicial process as it is, whether the judicial process serves the purpose that I've just stated of bringing social harmony from the perspective of ethnic minorities, from the perspective of religious minorities, from the perspective of transgender people, from the perspective of sexual orientation minorities, gay, lesbian people, and so on and so forth. So this is a way of looking at these issues where we recognize, where the society recognizes need to address the problems of the minorities from the feminist perspective. But this kind of drill, this kind of exercise can be done with respect to any other minority and that angle which that minority brings to society. Now, what is important to have in mind is that the law is inevitably subjective. Yeah, this is what Dusan Kajer from the political science. Yeah, the students of law, or mostly of you are, as far as I understand from law, the students of law know that we at the law faculties, we don't really speak so much about the subjectivity of law. We rather like to give impression that law is objective, and that Cettina also had a teaching experience for a long time, so she can confirm it. I'm sure from the Italian perspective. Let me put it this way so that everyone can see it. We like to give impression that law is objective and that we are some kind of priests, like lawyers, attorneys, especially judges and prosecutors, everyone who is occupying a public function related to the application of law, especially in a public function, a state agent or some other type of public agent. We like to present it as to make it look like law is an objective phenomenon, that we are sort of priests and we are applying the law like the priests are applying the Bible, preaching, subjective. That's also subjective, exactly. But we don't talk about we don't talk about that subjectivity either. Yeah. So we like to give this impression of perfection. Yeah.
We like to say that the judge is like an arbiter of a football match.
Yes.
Just looking that the rule are respected.
Yes.
But,
yes. Exactly.
Judge is like that, but.
And we know that even in the football match, it's never just like that. There is all we like to. I think that the perfect image of law is, in terms of application of law, is a chess game. We like to make it look like the legal rules are the rules of a chess game, but it's not like that. Why it's not like that? Because first of all, of the language. Law is one of the inevitable elements of any definition of law and legal system is the place of language in law. The language itself is thrown open to different interpretations. Every sentence can be interpreted differently. And we can say that from a famous, from the 60s, 1961, of course, this was known before, especially in philosophy of language. This is not a new thing. But in law, when we look worldwide, one of the books which made a huge impact on the studies of law across the globe is the concept of law by Herbert Hart. He's a British Oxford scholar, and he wrote and published this book in 1961. And that book became like, when it comes to legal theory, legal philosophy, it became like a Bible, really. I was in Oxford, and it's the scholars, they know by heart which page it is, and it's absolutely impressive to see. I don't know, like Norberto Bobbio, for example, or for example, in Serbia, it's Radomir Rubic, for example. It's like someone who, the language that we use, legal language, is almost the legal language of that community in Oxford, and thanks to the Oxford's influence across the globe, Herbert Hart's language became the language of everyone in terms of contemporary legal theory and philosophy. And what Hart pointed out is that there is open texture of law, meaning that law is open, the text of law is open to different interpretations and different meanings, that law is polysemic. And that even if we want to be, even if you don't want to be malicious, even if you want to be really as neutral and as objective as it is possible, like really to be as perfect, to try to be as perfect as possible, that even then we will come to the conclusion that most of the norms in law, they have a core meaning and penumbra of uncertainty. So there is we can agree, for example, for most norms, we can agree, or for many norms, we can agree what is the core meaning of that. But then there may be a wider or shorter penumbra of uncertainty as to possible other ways of interpretation. And sometimes this core is wider, and sometimes this penumbra is wider. And so we will come to a situation when one single norm can be objectively interpreted in different ways. And we can then list those possible interpretations. And then we will see actually how that penumbra is actually wide, how large it is, because it may be, as I said, shorter and it may be wider. Even if we want to be, as I said, as objective and not malicious and not intentionally abusive of this, because we can also abuse it. Yeah? We will talk about it. I mean, this has, as I said, made a huge impact. And so just to give you one way of how it is seen, it's not only in the UK, so it's not just in the Anglo-Saxon world, it's not just in the common law. In France, for example, you have theorists who say, like Michel Tropel, he says, well, exactly because of this penumbra of uncertainty, judges who interpreted the law are actually co-legislators, because they are in a position to interpret the law. They are co-legislators. And those who are in a position to interpret the constitutions, they're co-constitution makers. Because you have that position, that privileged position, that what you say is actually what the law is. So this is the privilege, and this is why we need to take a close look at how the judicial process looks like, because of the status of these public functionaries, these public agents, such as prosecutors, judges, and also attorneys who participate in this process. So this is why it is extremely important. Critical legal studies was a movement in the United States in the 50s and the 60s, which said in a very open way that far from being neutral, objective, and rational, the law reflects economic and legal power underpinning subordinating tendencies. So what critical legal studies said is something even different from what Hart was saying. They say that law is not neutral as such, that law is by definition. So one thing is the fact that obviously if the judges are co-legislators, everything depends on who the judges are and how they're going to interpret those judgments. And if we take into account that even the law itself is never neutral, and that it is always a consequence of the underpinning economic, legal, and political powers, then it opens even more the power of those judges and all other public functionaries and agents. These critical legal studies came from the Marxist tradition, and as a result of the Marxist influence. I didn't have yesterday sufficient amount of time to pinpoint that aspect of human rights law, that actually a very important critique of human rights law before the feminist critique came, the liberal feminism and radical feminism, etc., was actually a critique which came from the Marxists. The feminists only overtook one part of the Marxist critique, and the Marxist critique of concretely Karl Marx critique of the Declaration of Rights of Man and Citizen that we mentioned yesterday from the French Revolution of 1789 was that that declaration basically contains civil and political rights. It doesn't contain any economic, social, or cultural rights, apart from right to property. Okay, so this is, in Marx's interpretation of the declaration, this is actually the most important provision in the declaration, because it places right to property, right to private property, at the apex of the legal system. In his opinion, this is what the declaration is about the protection of the private property. And the protection of private property seems very neutral as such. Only when you look at the situation in place, especially at that time, who has private property, you will see that it only protects the rich, the aristocrats and bourgeoisie. So the declaration is not neutral at all. Whereas it looks like it gives an open space for the public participation of everyone, because it does guarantee rights of man citizen to participate in the public sphere, in the politics, and it looks wonderful. It leaves the questions of civil society, and the questions of civil society are economy, the private sphere, family. It leaves in the shade. So that is absolutely untouchable. This is not at all a matter of discussion, how the private sphere, how the civil, this is the term he used, civil society. He introduced it actually at Hegel even before, the concept of civil society. But it encompasses economic production as well. That part is totally unaddressed by the declaration and by many other declarations and the law as such up until beginning of the 20th century. The way the business was done, the economic production was done, was left to those who had power, economic power, exactly what the critical legal studies say, those who had economic power to organize it in the way in which they like. So this is the biggest deficiency of the declaration in the Marxist interpretation, that it doesn't look at the social reality. So the question of social reality, before it was addressed by the feminists in the 20th century, was previously addressed by Karl Marx and the Marxists much earlier. That it doesn't look at the social reality, it doesn't look at the social inequalities. And that hence it doesn't look at the individuals as part of the society, because the life in the society is actually what happens in those spheres which are untouched by the feminism, in those parts which are untouched by the declaration itself. So what is the purpose to have any particular right in the declaration if like freedom of expression or the freedom of association, if you do not have your basic needs satisfied, if you don't have your basic needs satisfied, if you're hungry, if you're poor, and you have to fight for your bare life, what does it mean to you? It doesn't mean anything. So this is the critical legal studies movement, which drew attention to these problems of law, of the fact that it is not neutral, it is not objective, it is not rational. It serves concrete purposes and interests of those who are in a position of power. Was actually addressed by Marxist theory, but by Marx himself in the mid 19th, second half of the 19th century, and deriving from that thought, from the critical legal studies, from that perspective, from the need. So the critical legal studies movement insisted on the need to look at the law critically and also to look at the legal studies critically. To what extent legal studies actually explain this phenomenon, or to what extent legal studies actually, by not explaining these underpinning forces, they actually help these inequalities to persist and to continue. So this is my critical race theory due to the problem of the racial problems in the United States. I mean, you can only just 2 years ago you could have seen to what extent the racial issues are present, are active, are alive. So although the civil war, which was about the need to allow for the African Americans to live just like everyone else, was in the 1861 to 1865, and although the war ended with the victory of those forces which were for the abolishment of the slavery, it is still not achieved. That kind of equality is still not achieved. It's still very much alive. I was like 20, 30 years ago in Atlanta and in Georgia, and I was in North Carolina, and I saw it myself, how much that kind of tension is still present in the air. Even I mean, I don't have to give you my own experience because you can see it yourself. Almost every day there is something new coming out from those problems in that field. So critical race theory places race at the center of its critical discourse and acknowledges the law's liberatory potential as necessarily coexistent with the law's subordinating tendencies. So this is what comes, as you could see, from the critical legal studies, the affirmation of the fact that law can be both liberating, but also it can be subjugating, depending on how you deal with the law. And this is why a feminist movement is very much present among the lawyers. And lawyers are very much engaged in that fight because they are aware of the potentials of law. Although, as I said, we don't really speak about it sufficiently. We exactly like to give this perspective of the law as natural, objective, and rational. This is the general perspective that we like to give, and especially that we, as interpreters of the law, are doing it in a very neutral way by itself. We'll come to those details later on. And hence, from the critical race theory comes feminist theory, which pinpoints that law is not a gender blind, that it neglects or even ignores the position of women, that we don't ask the woman's question. This is very important. I mean, I think you have addressed this with Professor Dragica in the feminist political and legal theories, the importance of asking women's question. We can, as I said, ask everyone's question, like from the position of any minority, because it is easy for the majority, but although, as you can see, what we think is a majority and we think it is in the interest of majority is not, because it's actually serves someone else who is disguised behind the majority who likes to present itself as being, so even majority is not sufficiently protected. Yeah, that's what Catherine McKinnon says. Even men do not enjoy those rights stated in the Universal Declaration of Human Rights, and even less. So that is the situation as it is. Okay, if you have any, as I said, as you know, if you have any questions or comments, you can interrupt me at any moment. And I especially say to you who are online, because I don't see you all due to the system, and so you can talk, you can say, comment at any moment. Just jump in, take the floor. And we need to insist even more when taking into account that law is a result, is a consequence of a power game, that we have to look what are the forces behind it. And this is why we insist on the intersectional analysis of law. By exploring how different identities intersect, the intersectional analysis of law provides us with a framework for understanding these deep structural and systemic questions about discrimination and equality. It contrasts the multidimensionality of Black women's experience with a single axis analysis that distorts these experiences. We do have to always, just as I said, even majority is not fully profiting from the system. We have to look at these intersecting identities, because it's not the position of every man, the same. Whether you have revenues of one level or another significantly affects your position, or whether you are handicapped or not significantly affects your position, or whether you're a religious minority or not significant, or whether you are gay or not, it all significantly affects your position. Women, as we had seen, have been for centuries and millennia in a disadvantaged position. So we need to address that issue in particular and take into account the number of women in society, and that they're in majority. We need to address that issue even more and particularly. This is why we have a feminist judgments as an exercise, as a drill. This is why this has developed as a concept, an idea that we should look at how the judgments are drafted, and whether, if it was someone else on the bench who had a different experience, different system of values, whether that judgment would have looked different. This is a way to show that, once again, that law is not neutral as we like to present it. So single axis analysis distorts this experience. If we just take into account position of woman, or even a Black woman, but not what are her revenues, whether she has revenues at all. This, because not position for every Black woman is the same. So this is something they have to take into account, these different identities which intersect. So this is, we may have a case of multiple discrimination. I think that Professor Dragica mentioned it, and we're going to speak about multiple discrimination with Professor Ivana Krstić with another in the course of human rights law. So multiple discrimination and intersectionality are not the same things, although many times they overlap. Intersectionality implies that these different identities mutually support each other in disadvantaging that person within that complete society. Whereas multiple discrimination may appear even within a context of a person who does not have this issue of intersectional identities. It may just be a coincidence that that person is accumulating different type of disadvantaging, let's say, features. So this is why we insist on storytelling and looking to the bottom approach. We try to address their issues and to show the falsity of the liberal promise. So the liberal promise, what I said previously, Marxist critique of the Declaration of Rights of Man and Citizen was actually critique of the of liberalism and the liberal promise of equality and freedom for everyone. This is like defining these are defining elements of a liberal ideology of liberalism. Rule of law, equity, equality, liberty for everyone. That promise was not achieved because we looked too much in the context of liberalism into formal equality. We didn't look at the substantial equality, and this is where the problem comes from. This is why we within this course, within this program, but academic community worldwide decided to the way the judgments are drafted and whether feminism or feminist perspective would bring something new to it, something different to it. So exactly what is the nature of the judicial process? I would like to just give you these different perspectives. The traditional understanding of judicial process, the modern understanding of judicial process, and different sets of considerations which are actually present in judicial decision making. So to kind of deconstruct the judicial decision making in order to be able to improve it from the feminist perspective. So for many for a long, even still nowadays, so for many centuries, even nowadays, the traditional understanding, I would say, prevails. And that is the understanding which was probably in the best way explained and given to us by Montesquieu in his book on the spirit of law. So this is the 18th century understanding of judicial function as subordinate, essentially subordinate to executive branch of government. So the understanding of the judicial function is even nowadays, I say, it is not so much different, essentially, from the understanding of the role of public administration. The way we understand the judicial function, and here it's very good. You can also intervene.
Yes, it's interesting what you say, but maybe this is reflect the different situation of Europe in the past, because this is maybe I'm wrong, but during the socialism time and in the eastern part of Europe, judges were more bureaucratic, and also the fact that still today in some countries, like in Poland, you don't need the judgment can be just without motivation, without the explanation, but only with the decision of judge. And this is a more bureaucratic approach. But if you look at the Italian experience, it's completely different, and the reasoning of the judge is the core of the judgment, and is a way to control that. In Poland, for instance, if you want to, you have to pay more. I don't know in Serbia if it works that way. And I was surprised because still today, people just go to the judge, they get the judgment, but they have to pay more for something that is a part of the how you can appeal if you don't control what was the legal reasoning.
Exactly.
The legal reason is that there are two parts. One part is about the reconstruction of the fact, and the other part is about the application of law and the interpretation of law. The result is through this. How you can...
You can't if you don't have reasoning.
How is possible that still today some countries not...
Okay, look, I agree with you, but I'll challenge you with that in the following way. I don't... you didn't let me finish my sentence. It is, what I wanted to say is that the judiciary considered it as a part of the executive branch of the government, with the exception that in the application of law by the administration, it is done in non-contentious situations, legally non-contentious situations. So when it comes to application of the law by administration, there is no contention, there is no conflict. Whereas the judgment is delivered in the context in which there is a conflict of different parties, individuals or state and individuals, or it may be a challenge, so it may be criminal, it can be administrative, and it is state and individual, criminal, the state pursuing someone, in the administrative when the individual sues the administration, in the private law, in the civil law when there are two individuals conflicting and they come before the court for the resolution of the problem. So this is the application of the law in contentious situations and the application of the law in non-contentious situations. Okay? This brings this, and I agree with you that there is a difference, cultural difference between Eastern Europe and Western Europe in that sense. But what is, I think, and this is good that you're here, what you can tell us is whether you consider, I mean, not you personally, but for example, the legal academic community in Italy, that judges are, well, Italy is very specific, I have to say. In many aspects, but because I'll explain it as well. Whether judges are perceived as political actors. In Italy, they have a big, Italy is very specific because judges in Italy can be even members of political parties. I know that. It's contrary to everything that you can imagine. Wow, yeah. And it's also not uncommon. I know that public prosecutor's office in Italy is sometimes very political as well. And sometimes they start proceedings. Some of them are considered to be under the influence of socialist leftist groups, and sometimes they even start proceedings for political purposes against some public figures in order to ruin them, let's say, maybe too strong word, politically.
It's not explicit.
Yes. But I would say Italy is really very, very specific, peculiar. What I think you would agree is that in Italy, you don't perceive in general the judiciary as a political agent.
No.
Okay,
no,
this is this is my point.
This is no.
Yes.
It's independent power.
Yes. This is
obliged to apply the law without any influence of power. There is a Consiglio Superiore della Magistratura.
Which protects them.
Yes, in order to avoid that there will be some influence. So for us, it's
good. This is perfect because this is exactly the point I want to make. The judges are political agents. And contrary to the way we usually perceive them, and this is where it comes from this Montesquieu's image that he gave to us, and then due to his heavy weight in political and legal theory, we just adopted it, and he made a huge impact on the American and French, but not just French, but American Revolution, and his understanding of the separation of powers. So he says in the famous book 11, chapter 6 on the Constitution of England, he says judicial power is null and void, en quelque façon nulle, and judges are only a mouth speaker of the law, inanimate beings who cannot mitigate its force nor severity. This is this image of perfection that we want to give. This is also called in legal theory mechanical jurisprudence, understanding of judges as some sort of logical machines. Like there is a major premise, there is a minor premise, and there is a conclusion which comes as a sort of a logical inevitability.
Yes.
But it's not really like that. It's not.
Otherwise, we would not have a problem with the stereotypes.
Yeah, for example, and also AI would be perfect in doing this job. So what I want us to look at is the modern understanding of the judicial process. This is not, I'm not taking this position, don't get me wrong. I'm just trying to objectively see things as they are. I'm not saying that judges should be political power. I'm just saying that they are political power, whether they want to admit it or not. So if political power is defined, in order to save time, I'm going to read and then comment. If political power is defined by decision-making, which is legally speaking discretionary, so this is when we speak of difference between political and legal power, or between the politics and law, or political agents and legal agents, we say that in principle, political power is defined by decision-making, which is discretionary. The higher that political power is, the discretion is wider. For example, when you adopt a constitution, the discretion is the widest. If you're adopting the laws, you're above the constitution. If you're adopting administrative decrees, you're above the laws and the constitution. So this discretion is not absolute, but there is a certain discretion. Whereas we want to make law look like there is no discretion. This is the image that we want to give. So not bound by law, the political power, and which has a collective effect, then it has to be admitted the judicial office is to some extent also political. Okay? So this is a definition by Charles Eisenman, the French theorist. This definition of political power, that it is discretionary decision making, and that it is collective in its effect, like this decision making affects everyone or almost everyone, and it has a public force. It's not just a matter of debate. You have a capacity to implement it because you are a state and you have as a state a political power. So judges do enjoy a certain liberty in the interpretation, exactly because of the nature of the law, both of the facts, as you said. Yeah, the facts can be because the facts when it comes to the interpretation, is the fact that a matter of interpretation. It is the law which is the matter of interpretation. Yeah? So both of the facts and of the law in the cases before them, as a result of which they create, especially when it comes to highest jurisdictions, their own case law. Yeah? The Corte di Cassazione.
Corte di Cassazione.
For example. So this is it. So they create their own case law.
Yes.
Yeah? And this is good because the case law gives a certain predictability.
Yes.
It gives predictability to the individuals who come before the court.
Yes.
And it also limits this discretionary power.
Yes. In a way, it's an instrument to give a certainty of legality.
Exactly.
La certezza.
Yes, it is. Yes, perfectly.
Not just random.
Yeah, you can interpret it this and that way. There is some there are some standards there. Yeah?
Yes, there is some standard.
Although it doesn't have the force of legislation and it doesn't bind the lower jurisdictions in the same way in the common law as in the civil law system, it is in practice generally followed by the lower courts under the supervision of the higher courts. Actually, I should have changed here the position of common law and the civil law, because in the common law, they have a stronger legal force. Yeah. The precedents, what we call precedents, they have a binding force, whereas one of the terms that we use in theory is interpretative force that they have in the civil law jurisdictions. That it is by the nature of their quality, by the nature of their persuasiveness, that they quality of the arguments, that they impose themselves upon the lower jurisdiction. Also, depending on the different civil or criminal procedures rules, you may have a situation when the higher court has an opportunity to actually impose its interpretation by taking the deciding the case itself. So that is where it has a possibility to have the final word, not just to leave it to the lower court's willingness to or non-willingness to follow. So what I want to say is that judicial process, what we have to admit, that judicial process is a political process, and I'll go more into it, in the sense that creation of the case law is also a sort of policy making, because this case law, although it limits the judiciary, but the fact that it exists is something which is a way the judges see the law should be interpreted. And so this is their interpretation of the law. And this is their way of lawmaking, the case law which they develop. Okay. So I give some famous landmark cases of judicial. One of the terms that we use, but it's not really always the best, is judicial activism. These are really the cases of so-called judicial activism, although it is clear that the opposition of judicial activism is judicial restraint. Judicial activism is when the courts take, let's say, a bold decision in interpreting that piece of legislation. Here it is the Constitution. For example, Marbury versus Madison. I briefly mentioned it yesterday, a landmark case in 1803, when American Federal Supreme Court decided in 1803 not to apply the law, which was supposed to be the basis of the decision making in that particular case, because it found that piece of legislation, that act was contrary to the Constitution. Now, why was this a case of judicial activism? Because nowhere in the American Constitution then and now it is stated that the Supreme Court or any other court has this power not to apply the acts of the Congress if it is contrary to the Constitution. So this is not present anywhere. And this is why you have a very strong also current among the legal scholars in the United States who say, for example, one of the titles of one of the books is taking away the Constitution from the courts. Take them away the Constitution because they have no right to actually use the Constitution as a standard of deciding whether the act is in conformity with it or not. There is a very strong current among the scholars, and there are also those on the bench who are very conservative. They say, look, there is no word about it in the Constitution, so how can we use it? And then they especially are those who and this is contrary to the feminist to women's rights and to gender equality in general, they say, okay, if we have to apply the Constitution, we have to do it in the so-called originalist way. Not to see the Constitution as a living instrument, as an evolving document, which changes its meaning just like language changes its meaning with time. But we have to look at it in the way the founding fathers were drafting the Constitution. So we have to put ourselves in that position, that perspective of the original, those who adopted the Constitution, and then you can just forget about so many rights that in the meantime the Supreme Court and other courts have actually developed. So this is why it's still a matter of contention, the debate. And I have in the United States, and you have seen it yourself with with the reversal of the Roe versus Wade judgment of the Supreme Court. So the mere fact that the court decided to reverse Roe versus Wade and to say that there is no right to abortion recognized on federal level is an example of that kind of understanding of the things. And this is why exactly it was a landmark decision. Another landmark decision, which I intentionally take from the French legal system, because it's a system which is very, again, where there is a strong opposition to any kind of judicial lawmaking. So there is a strong tradition of, of opposing both among the politicians and in the among the scholars on the bench as well. Just to give an example of why the case law is a sort of political power. To give you an example of this. Language from the French dictionary. Exactly because he recognized the fact that judges, through jurisprudence, have certain maneuvering space. It's a sort of power which they have. And this is why in the period of revolution, they even had a mechanism which is unfortunately still present in Serbia. I mean, but it doesn't function the same way. Which is called the authentic interpretation. I don't know if you have
Interpretazione autentica.
Yeah, interpretazione autentica, which comes from the body which adopted the text.
From the legislator.
Yes, from the legislator. Now, in the Serbian distorted version, it means that the legislator itself can interpret can resort to it.
Yes, when some problem of interpretation came out and it's not clear even inside the bag of judges, the legislator will intervene and will write interpretazione autentica
to say what the law was meant supposed to be. Yes. Well, in this period back to late 18th century, there was a law in France which provided for it. The judges were obliged to make these referrals to the legislator whenever they had a question of interpretation. Whenever they had a question of interpretation, meaning because again, you know this Latin saying in claris cessat interpretatio, or interpretata, or clara non est interpretandum. When it is clear, we don't interpret. So, and as we want to give impression that it's always clear, we don't interpret it. So, whereas we have seen, of course, we interpret all the time. So they were considering that whenever you have doubts whether it should be interpreted or not, when you are actually sure that it should be interpreted, but you don't know how it should be interpreted, you have to refer it to the legislator. Of course, it is impossible to imagine that kind of. Either you will have a situation where no one will do it, or you will have everyone doing it and blocking the process, because it's not possible to apply it. Well, exactly in that country, a French Constitutional Council, which is not even a body which was intended to be a full-fledged constitutional court, when it was adopted when the Constitution was adopted in 1958, that body, the Constitutional Council, dared in 1971 to introduce the Declaration of Rights of Man and Citizen in the so-called bloc de constitutionnalité, the block of legal texts which are considered as a standard for the review of constitutionality, so that there are any human rights on the constitutional level. I gave you yesterday a positivist definition of human rights, and I said that human rights imply that they are enshrined in a supra-legislative document above the legislator. And if you don't have it in the constitution, you don't have it. So the French Constitutional Council said that, okay, the preamble of the French Constitution makes reference to the declaration. So you don't have in French Constitution, you don't have any single human right. No, there is no charter, no charter. But it makes reference to the declaration. The preamble makes reference to the declaration, and then I will not bore you with this issue among constitutional scholars, whether preambles have a legal force or they don't have a legal force, blah, blah, blah. Anyway, the French Constitutional Council said, well, it is said in the Constitution, preamble is part of the Constitution, the reference is made to the like being inspired by the Declaration of Rights of Man and Citizen, the French people adopt the Constitution, blah, blah. He said there is a reference, we're gonna take all the rights and liberties drafted and declared in the late 18th century, and we're gonna interpret them from our current present perspective. So this is what a landmark judgment. It's also called Marbury, the French Marbury. There are also those in the European Union laws, such as Costa versus NL, and and Van Handel laws, judgment of the Court of Justice of the European Union, which are considered as Marbury judgments or Marbury moments of that Court of Justice of the European Union. Another very interesting case I want to share with you is outside of Europe. It's from Israel. Their Supreme Court, in this judgment, United Mizrahi Bank versus Miggdale Village, decided that that initial 10 acts, legislative acts, which were adopted after the State of Israel was established. Whereas Israel, even nowadays, doesn't have a formal constitution. It doesn't have a constitution at all. Formal constitution. No. But they adopted these basic laws, what they call basic laws, 10 texts. Not in one go, over time. They adopted and they said, these are basic texts. The legislature adopted like that. The court said, the Supreme Court said in 1995, we're going to treat these states, these 10 pieces of legislation as the Constitution. And we're going to start reviewing the constitutionality of any other piece of legislation that Knesset, the Israeli parliament, adopts on the basis of these 10 pieces of legislation. This was a Marbury moment of the Supreme Court of Israel. It was a famous Aaron Barak is the name of the Supreme Court judge, who was the president, professor as well, and he he said it is time for Israel to move forward, because if you don't have a constitution, if you don't have that possibility to review legislation and to check the quality of the legislation, then you can't really be called a rule of law state. So it is time for Israel to have a sort of constitution, and this is what they did. This is just to show how judges can be very progressive. Or there are those who consider that these are actually not at all the precedents to follow. And this is actually a very bad example, because they're abusing the power.
Power, he literally invented the constitution for Israel. He said that. In
a way, they invented the constitution for Israel. They took it from the willingness of the first legislator, from its consideration that this. They didn't say this is a constitution. They said these are the basic laws.
Basic laws. laws and they have some like speciality.
No. They have these basic laws, which are like one is dedicated to the human rights, the other one is dedicated to president, like what we would call organic laws dealing with institutions, like president of the republic, parliament, elections, judiciary. These are what these basic laws are about. But you can imagine that, first of all, these are basic laws. It's not one section of the constitution. It's huge as a document, and altogether, when you take a look at it, and it therefore gives a particular wide power to the judge, because it is one thing if you have a document of, let's say, French constitution has 89 articles, or Serbian has 206. It's one thing to have a document of 120 articles or even 300, but then imagine having 10 laws as a standard of review. So this is to show how actually legislator and how actually a judge can be a political actor. Yeah, and this is one of those. These are just, of course, the most obvious examples. Okay, I will. Now it's like we've been talking for 1 hour, and maybe we can make a break now. And then we don't, because I've been talking for actually more than an hour. So we make a break now, and we have just one break. In 10 minutes, we come back and we have the second half without making 2 breaks. Okay, good. Because then I will start with just further unpacking of this judicial process. Thank you. So let's come back in 10 minutes. Bravo. Ina priča se.
Malo. Idemo je 90 nešto. Može. Šta je bilo?
Dobro je znamo, mnogo je ispost.
Ne.
Ja sam ne mogu. A nije preskačno bilo kako se gledaju naviknuti kako to izgleda, kako to pušteno čak.
Da.
Ja znam što domaći ljudi što mi je human rights. Ja ne pratila lično.
To ne. Ja nije.
Znaš na tebe,
Može da pravi. Baš je bilo preko toga.
ja nisam pitala što kad odmorala.
Ja sam radila ove zajedno domaći.
Ali nisam znala. Ali ona je što je dala Boris Pajić.
Izbrošla te?
Ne.
Ojoj.
Ona što mi je dala Boris Pajić. Boris Pajić. Na
Nije ti dao da pomoć?
Ne, piše. A pozovala sam.
Da piše.
Ajde, bilo za 25 ja sam nešto prebacila da je 25 decimog do kraja dana. Međutim, nije bilo je
Ajde, sad što gleda.
Ne, možete, ali...
To je još taj decembar.
Ne znam da li je gledala kao papir da...
Kupila sam kartu na kupomate, koje muka bijelo.
Nam kao instructions na rad, ali ja nemam 14. I da je prvi deo od 12. i 20. decembra, onda 12. pa... Ne, super.
Dobre, draga, se da je, Spajić je li danas?
Dakle, evo ja sam
Za
Ja
nas?
sam bila danas.
Kako
Još dva bila. je bio ovaj court case.
Da, na listi, to je da vam vas pitanje, za ocjenjivanje.
Možda to nešto.
Nemam pojma.
Je dan.
Aha, sad ima se biti prije ovo na jednu.
Cijeli.
Ja sam poznala to spita.
Ne potem sam se uopće.
A čekaj, ja idu 2 do 19. 2 do 23, 2 do 30.
Da. Trebalo bi dvojen da još.
Još?
Koliko ti sad tu?
Ne bih na bilo tako.
Već ja uvijek uradim sve, mislim glasno sam završila sa ti uvijek pored. Kad ja uvijek uradim sve, mislim glasno sam završila sa odlično. Bukvalno sam uradila svih 11. Što sad tebe radim? Ja sam kući kad bi znala to je do 2 dana sam to radim.
Ja nisam, imam praktivano, imam to praktivano. Zadnja lola, dobro, imam praktivano, a ja sam to, ajte reći će biti tu ili ne rap, napravit ću ovo poslušati.
Da, ja nisam uopće sigurna da ovo dobro
Ali, kako sam, znači, for the first lecturing unit, 4 assignments, November 26, November 29, do 20. decembra. For the second lecturing unit, 4 assignments, 2 per lecture, do januara 9. To ne. For the third lecturing unit, 2 per lecture, do januara 23. I kaže, for the fourth lecturing unit, 2 assignments, februar 2.
Molim da se
pokaže.
Molim da se pokaže nešto novo, javite mi ja ću mi da ulazim na
Kaže 4, 8, 10, naravno. Ne, ali ovo slovo. Zato što se za svakog dobro pojegao. Šta ti se dobije po formu? Naravno dobije...
Ne znam, hoće da klikam kao pola čega pojem. Ne znam.
Može, probam. Ne.
Ovo idući.
Imam ja strane.
Mnogo lepo.
Sudina.
Korekti, zdraviću.
To je da.
A možda ima nešto druga.
Da, samo tako da. Ima pokon tu. Ne znam da budemo.
Bravo.
Mislim.
Yes. Yes, we're going to. I'm Erasmus here, so. Something. Great.
I kao da te pare platite.
Ma da.
Ili tu tražimo da nekako dječki ili drugi, i tražimo da nekako bi ono, kad je bilo da kao tipki, kada je bilo da bi Beograd, ja rekla, volte,
Ja sam rekla malo već, a ja da
kako bilo da se volte. Je problem, ali da, ona je sam je pisala, ja odgovorim, ja odgovorim, rekla, student, ne rekla, i sam je pisala, da je sam htjela da je dala, because that's what I was doing. I bila toliko konkretna. Ja sam na kraju dnevnici bio kao da je pola 12 prošlo. I ja je to da kao da ja završim i dobim ovaj rad, ja ne bih rekla sam kiške, da ću sam čekala cijel dan. A jutro sam čekala, znači cijel dan sam čekala da idem na red, možda sam reći pola 12 prošlo. I ja idem da stavim odnosno da napretila da vrata, tako zaključu. Ja zovem mamu, i kad sam bila 3 godina, a u noći je da napekao. Kaže da ću mara ovdje da nekako, ja sam uvutala na baš, imam se tako predvidi po mama. Ne, koji mi ovdje kućeri. Jer tako je, znaš, otišla je zapravo, ja sam uvijek. Ne, ali kao, ne. Na to se ne opovrti nešto što budeš sam sa ispitivačima. Uvijek moram da je neko da ne gledam tu je ovo. Ali kao to je neću ne kada će ti sad gledaš što sam čuvala.
Ja im kabinetu svog šrata ljudi. I daje i niz pečenja. I ne znam čega sve bilo dolazi. Da ne pričam, znači i ovdje.
Da, verujem da ima ima povoličan svakako, ali kao je ovo da šakne se gleda povoličan. A tu ja ne znam. Eto, ne znam da vidite da je ali ovo vaše je 10 mesta i skoro na 10 mesta. Da, vrlo kritična institucija, ja sam bila sad vrlo vačno načal. Zbrane. Da. Ne da bavim. Ja sam kada želim ja sam svi ali malo se svima a ne da imate neki poslovno neki tamo, ali opet pa svi moji imamo ja se imamo stavljamo ja mi spolno će da radim druži Bukvalno, ja imam prijatelj tako da ljudi, to kao prvo su znači bičene i to kao mene bili. Ja sam odlično. Ne znam, bio kao ne učenik se pravo i ono koji ide kao što je najbičnije. I to znaš, ne je bilo djede. Onda je kažem kao jedne godine bilo premijara na vladu. Kao, ajde, da idem i upravo jedan devojka koji je napad na Dubajcu, idemo na zadanje na osnovu kontre. Znači, ti je profesionalno, znači, ti idem na vladu. Ona je kao premijara, to je gledam predavanje. Nema nikoga, nema samo otvaranje, znači, ceremonija otvaranja, nema nekako, mi prišamo da nema nikog, a žurke uvek ovako pune i svi.
Znači, broj kada sam prišla fakultu, su nešto drugo, događa se mi sede druge. I ja da me prošla, me koja da vidim da je taj. Vidim, ja vidim, pa vidim sam, sad sam molila da posle do jeseni da neko samo da me šalje. Ja sam tamo, ne znam, dođe ovo majka moja.
To je stvarno ozbiljno.
Ajde ti ono, da ja sam spoznam.
Da, ali mislim da sam da je jedan pol da je koliko ja pogodim da sve, je li ima zašto zašto tako? Zato što pišu prije 6 godina moja ne može. Da se tako gleda. I ti, ajde bilo 1006. To u drugoj godini je već bilo. Što samo naravno tako biti standard da ne možeš da mora biti od nas je oko 720. Ja sam učiš pa da, ali ono, i onda da otpadne malo teško i tako nije bilo. Najviše je to dobro. Ja vidim naš bolji ne? I stvarno se nakon to mi dobro se nekada na tako. I to je bilo uparali pameni pravi doći. Zavadili bolj čorbu. Ovaj tako tekton manje gledate što dajte vidite ovi koji dodaju kao ne znam kao prvo na čovu. Ja idem svaki dan u školu. So, it's better for me because
We can decide what the topic is going to be, so you can.
Yeah, and I mix.
Yeah, sure. Yes. Okay, so well, let's see from everything we have said. That was the tool. Benefite, pošto se pomerate. Yeah, sure. I think because there are parts, there's some parts which are leaking ahead of the building. Yeah, we were all scared. Okay, so now let's look at the way actually the models of judicial decision making. Let's take a look at what affects judicial decision making. Yeah, and these contexts or these sets of situations is what we call models. One is the attitudinal model. Yeah, it's let's say it comes from the attitude. Yeah, I will read it in order to save the time, and then I will comment, because if I start talking, I will never finish this lecture. Judges' decisions reflect their ideological. So, attitudinal model insists on the fact that judges' decisions reflect their ideological preference, tempered, of course, by case details. To put simply, liberals decide cases liberally, and conservatives decide cases conservatively. Yeah. So, in other words, we can say that any conservative text can be interpreted by a liberal in a liberal way, and any liberal text can be interpreted by conservative in a conservative way. This thesis is supported by a number of apparent facts. Constitutional rules or any rules governing decision making do not limit discretion. Justices need not respond to public opinion in other branches of government, and constitutional courts are the highest in judicial hierarchy. Okay, this is doesn't have to be about constitutional courts. It is. I was more being a constitutional lawyer. I was focused on the constitutional court, but this applies to just any court. This attitudinal model insists on the way judges are brought up. It insists on their ideological preferences, but it can be a matter of their education. What kind of values they adopted in the families in which they were brought up. What is their mood in the day of decision making? And some authors even analyze it, and they say it's that the judges, it's called realistic jurisprudence, this part of the jurisprudence of the United States, and they say that basically what judges had as a breakfast that morning will decide the case. This put to the extreme this attitudinal model. But one good example of this attitudinal model is, and I will not actually explain this example. You will have this presentation, so you can read it. Is actually how the American Supreme Court in the period between 1890 and 1936 actually prevented adoption of progressive legislation. Actually, the legislation was adopted, but they were constantly deciding that progressive legislation, which was Roosevelt's new part of the New Deal, a more socially engaged legislation, was contrary to the laissez-faire doctrine of economic liberalism, and that because the Constitution was adopted in the period of economic liberalism, laissez-faire doctrine, that this this new legislation, which Franklin Delano Roosevelt advocated for, was contrary to what the Constitution says. So this shows the importance of this part of this aspect of the judicial process, and that is who the judges are, how they are brought up, how they're educated, what are their ideological or preferences, or what are their values in general. At the same time, judges they have normative constraints. So even though we are aware of the attitudinal model, and the attitudinal model is present, there are also normative constraints to how judges decide cases. And the definition of the actual process of judicial decision making, he has to take into account these constraints which limit justices. If it is true that laws, constitutions, statutes, and precedents always allow for certain discretion in judicial decision making, it also has to be admitted that judges are subject to expectations on how they ought to behave in these situations. And they also have their own perceptions of this, which is relevant too. For most of them, this includes providing orderliness and predictability of law, as well as maintaining strict legal consistency. It follows that courts are not quasi-legislators, and that they have to demonstrate impartiality by respecting certain rules and procedures, which is not without consequences for their legitimacy. This is what Tina was explaining, that they have to reason their judgments and they have the procedures. So these are the objective normative complaints. They have to give arguments for their judgments, and that limits them, you know. So that is something which, no matter how strong the attitudinal model, this also limits judges in the decision making, the normative constraints. Okay, you will hear, you can read here, when I send you the presentation, a very interesting passage from Benjamin Cardozo. He was an American professor of law and a judge at the Supreme Court, about the nature of judicial process. And here he explains how different types of interpretation actually influence, like what we call historic interpretation. Like, but if there is a need to interpret, then you have to take into account the history of how the document was adopted. Or you have to take into account what we call structural or systemic interpretation. How does that norm fit into the wider scope of the norms of that text? Or you have to take into account what is the purpose of that text, you know, even though it is not clear what was the aim of that text, what was its purpose. Or you can take into account comparative law when you know that this was adopted on the basis of comparing or on the basis of what we call cross-fertilization, when we adopt the models from other countries. So all these methods of interpretation, different methods of interpretation, limit judges in their process. And they're part of this normative constraint. They have to obey by certain standards. So some judges who even have very strong this attitudinal model, who are also brought up in a legal culture where this is respected, will definitely have to take into account these normative constraints, and they will have difficulties fitting their very strong attitudes into those constraints. Yeah? And then there is a strategic consideration. Besides ideological predilections and normative constraints, constitutional or any other adjudication is shaped, at least to some extent, with regard to the positions of other institutional actors, if not for other reasons, then because the courts are dependent upon other departments of government for the effective implementation of their decisions. So they will, in that respect, justices act strategically according to the principles of the rational choice approach. Social actors make choices in order to achieve certain goals. Social actors act strategically in the sense that their choices depend on their expectations of the choices of their actors, and these choices are structured by the institutional setting in which they are made. Therefore, a strategic model which comes close to the separation of powers approach points out the importance of the institutions in a society as they prescribe and proscribe behaviors, but it also reveals the potential insincerity of judicial decision confirming the courts of judicial decisions, confirming the courts' dependence on their environments. Basically, the courts will also take into account what is the position of other agents in the system, other branches of the government. This may not be, it doesn't mean a subjections of the courts to the executive branch, for example. It means that the court will take into account whether that type of argument is going to be implemented by the executive branches or branch of the government at all. Because if you see, for example, in the United States, how a very capricious president can impact the whole world. And you can imagine how he can impact even more his own country. Well, I'll give you an example which is from the beginning of the American constitutional history. The judge the president of the court who adopted this judgment, Marbury versus Madison, was John Marshall. He's a famous name. And he also, after that judgment, he adopted some other very progressive judgments. And at one point, the president, Andrew Jackson, said, after Marshall has adopted one of those progressive judgments, he said, well, now I will let John Marshall implement that judgment. He was joking, of course, because Justice Marshall cannot implement anything. He's totally dependent on the executive branch of government. And if the executive branch of the government doesn't want to implement it, it's not going to be implemented. So there you see, and just take a look at this example. I don't know if you have followed but 10 countries, among which is Italy, Netherlands, and some others. They have addressed the European Court of Human Rights just a couple of months ago with a letter asking from the European Court of Human Rights to change its case law when it comes to migrants. This was the first time in the history of the European Court of Human Rights that you had a letter, basically governments rebelling against the case law of the European Court of Human Rights, which they find to be too supportive and too protective of the migrants, and limiting their power as governments in deciding who is going to stay and who is going to leave, and how that procedure is going to be done. Now, I'm not in a position of the judges of the European Court of Human Rights or the registry of the court, of the lawyers who work there, but I'm pretty much sure that that kind of letter does affect them.
It's a political pressure.
It's a political pressure. On one side, it shows also the power of the European Court of Human Rights, because obviously it adopted a case law which they dislike, and then whether they are within the limits of the convention or not, it's a matter of, again, of the interpretation. But when this is addressed, and after I mentioned yesterday the fact that Russia was expelled from the convention system, from the Council of Europe in 2022. I can also tell you that the new conservative the new Conservative Party in the UK, the present Conservative. One of the latest documents of the Conservative Party in the UK is announces that suggests that if the Conservatives come to power in the UK should leave the Council of Europe.
Mm-hmm.
So just imagine that kind of blow to the Council of Europe.
Mm-hmm.
Another Brexit. But this is in the context of countries where there are many others who are unhappy. Okay, there are also some EU member states who, are not 100% sure about their destiny in the EU. But just imagine how maybe some other countries, and definitely not as democratic as the UK government is, would actually be very happy to leave the council. For example, Turkey. Yeah. Yeah,
Yes, the question about refugees was brought to the European Court of Human Rights, and the freedom of movement. Cyprus, Italy, Netherlands, they are all in EU.
Yes.
They have their own EU legislation for the freedom of movement.
Yeah.
Why they don't say, okay, we are gonna step aside from the EU for this question? Why it's easier to go to the European Court of Human Rights for this question and make a threat?
Because European Court of Human Rights within the freedom of movement within EU is about freedom of movement once you are in the EU. But the European Court of Human Rights, in its standards when it comes to freedom of movement, through its case law, develops once you are in the Council of Europe member state, whether you can stay there or not. So the case law of the European Court of Human Rights allows you to be in one of the member states of the Council of Europe and potentially one of the member states of the European Union. It is true. All of these member states, all 10 of them are member states of the European Union. The EU legislation allows you to move within the EU, but the Council of Europe, let's say, case law of the court allows you to enter and to stay in the Council of Europe. So in that sense, it is, and so far the court has been very protective when it comes to instances when the families are already in the Council of Europe member state. It's a question of right to family life under Article 8 of the European Convention, or it can be a question of a possible question of the right to life or a prohibition of torture if you were supposed to be sent back to your country where you are actually fleeing from. So it is in this way that the European Court of Human Rights has developed a very protective legislation when it comes to refugees and to the potential refoulement.
But just to make a parallel with this, just with this, here I'm pro-refugee.
Yeah, sure. No, it's okay. It's a legitimate question.
This is hand in hand goes with the Istanbul Convention.
Yes.
And a recommendation for foreign recommendation talked about it on the Maria. The last it was in 2024.
The CEDAW.
No, not the CEDAW. We have EU recommendation. It's regulation for direttiva za žene. So they passed that directive, in a kind of safety net for those who are against the Istanbul Convention, but they are still deciding in what aspect they want to implement this directive as well as the Istanbul Convention, not cross their sovereign rights. So, so we have here the practice of European Court of Human Rights and also the EU freedom of movement, their own fundamental rights. Can they, saying
yeah, sure. No, they're exploring different legal venues, the mechanisms they have. So you suggest that they should try to do it within the EU legislation.
Are they deciding to go against it? That's why they are seeing the European Court as a easier target for this, as well as the
because European Court of Human Rights is actually above. There is also that big debate of the rivalry between the Court of Justice of the European Union and the European Court of Human Rights. This is a long process of accession. We were almost one step away from accession of the European Union to the European Convention on Human Rights and inclusion of the European Union as such in the European Convention on Human Rights, where the European Union would have its judge among the 46 judges of the European Court of Human Rights. So still, we consider that when it comes to human rights protection, because the European Court of Human Rights has a longer tradition than the Court of Justice of the European Union, it is above the Court of Justice of the European Union. So,
it's not an easier target, but it's like a more significant player.
It is a more significant player. And also, maybe the next step, it's possible. The next step would be amendments to the EU legislation. I don't know what is in their mind, because this came really like a bomb, like a bombshell. Yeah. The fact that these 10 countries
EU is kind of above.
Oh no! In that sense, European Convention, the Treaty on the European Union makes reference to the European Convention. Okay. In the meantime, European Union has adopted its own Charter of Fundamental Rights, and the Charter is, richer in rights than the European Convention. But when it comes to the rights which are guaranteed by the European Convention, the court in Strasbourg is considered as being above the European institutions. It's a question of also rivalry, dialogue, but this part of case law comes from the Strasbourg. protected in terms of protection of minors. So this is the kind of strategic considerations that I'm talking about. It's not about submission of one branch of government like judiciary to the executive, where the judge will. It's not a kind of telephone justice, okay? What we call when the executive directly makes pressure on the judiciary, or it can be some other someone who is economically powerful who may make, or who is some outlaw, someone who is making that kind of, or media pressure. It's about that kind of strategic consideration. How would that kind of judgment be seen in the environment in which the judge takes the decision? How would other actors in the system of the separation of powers would react to it? So this is what is meant by strategic considerations. And when you take it all into account, you can say that the judge's decisions are a function of what they prefer to do. This is the attitudinal model, tempered by what they think they ought to do. This is what we teach. This is why the schools of law are important, because the more values you pass on to the future judges and prosecutors or attorneys at this stage, the more they will be inspired, and they will consider that this constrains them, because it's a bit discriminatory. Age-wise, this saying, you can't learn an old dog new tricks. But it is true. Once the judges and prosecutors, establish their families, once they are in function, when they establish their families, they have other obligations, they can't take courses how to be a good judge. How to embrace certain values. This is why rules of law are important in passing these values at this stage. And unfortunately, we don't speak about these issues sufficiently, So the judges' decisions are a function of what they prefer to do, tempered by what they think they ought to do, but constrained by what they perceive is feasible within the given context, how far they can go in their judicial activism, as I said. Now, to come closer to the issues of feminist judgments, this was all to explain the nature of the judicial process. Now let's look into the role of cultural, religion, and gender. And again, I'll read this because I think if I start talking, it's gonna just we will never end. Religious practices support the patriarchal gender relations, specifically subjection of women to male domination within family. The clash between cultural, religious, and gender equality arguments has arisen as a constitutional issue in secular countries. I gave this example yesterday as well. As a constitutional issue in secular countries, where religious Muslim communities demand that their women and girls observe the dress code. So this example, which I started unwrapping yesterday at Anastasia's question, shows how the cultural context is important. How much culture affects the behavior of individuals, and it also affects judges through what I said. What is attitudinal model, the culture they were brought up in, and this particularly the interplay of culture, religion, and gender. This particularly the weight of the culture and interconnection between religion and culture puts that weight and that connection puts minorities within minorities in a very specific position. And it is when you take a look at the issue of ethnic communities and ethnic conflicts and religious communities, religious conflicts, it is usually the women or children, the youngers, who bear the brand of those of the culture and the importance of the culture. Because on one side, we favor cultural group rights. I was speaking yesterday about the group rights, importance of the group rights. such as ethnic rights or religious rights. But we have to be aware of the fact that when we, at the same time, while promoting those group rights, we risk of disadvantaging those who are minorities within those minorities, in those groups, such as women who are in those groups and who bear the brand of that of recognition of those group rights. So here for us, the very important issue is the question of judicial culture. One of this is actually the article that I will send you. Although my main points are not, I'm going to share with you now orally, and I'm going to put it in the presentation before I send you. This is why we insist on the importance of the way what we teach at the faculties, what are the values that we establish here, because all of that is shapes the culture of the judges, the way they think. So it affects both the attitudinal, normative, and strategic way of addressing the issues. Judicial culture is a part of a wider concept of a legal culture, and there are different ways of defining culture as such. Culture is the civilization that we created. Culture is something more specific about its art, but culture is also the ways, the customary ways we think and behave. We speak in that sense of judicial culture. We can speak of police culture, the way the police behaves, or some other agents, public agents. So what are the customary ways that we behave when we, in the context of law, when we interpret the law and we apply the law? So this is the context, this is the meaning of the culture that I'm interested in, because our need to address the way the judgments are drafted from the feminist perspective is actually our need to address the way judicial culture functions in the given society and what kind of judges we have in that society. So in that sense, judicial culture is both a subjective concept. It's about values, customs, beliefs, in symbolic practices by which men and women live. But it's also an objective concept because these values are manifested through customs, practices, and human relations and institutions. This is not just what we have inside, but how we manifest it. It's both subjective and objective. It is important to look at judicial culture because judges are powerful state actors, and the way they decide matters affect every aspect of our lives, whether on societal or individual scale. And in this sense, contrary to the conventional belief, judges are not only, as Montesquieu would say, mouthpieces of the law, but very often they're very creative interpreters. Yeah. Mm-hmm. And I have developed this, I will put it here for you as well, a typology of the types of judges with respect to their fidelity to rule of law. Yeah? So I have developed the concept of typical type of judges and atypical type of judges. The typical type of judges is judge bureaucrat, that you mentioned, and the judge power. Okay? So my standard is their fidelity to rule of law. Because rule of law as an ideal and principle is supposed to guide practitioners in their implementation of law. Rule of law is not supposed to just stay somewhere written in the Constitution and the text, and that it is not applied. I consider them to be typical. Judge bureaucrat and judge power. Judge bureaucrat perceives, this is the one that you have, this is the context in which you use the term bureaucrat. When the judge perceives itself as just a contentious part of the executive branch of government. So it applies the law but it's not particularly, it looks the law in a very limited way. It looks the facts in a very limited way. It doesn't poses itself bigger and wider questions.
Mechanical.
It's a sort of, exactly, yeah, it is a mechanical type of jurisprudence. Well, yeah, but Judge Power considers himself or herself as a true branch of government. And that type of judge sees well-established case law as a way of sort of judicial lawmaking. So that through well-established case law, I gain power. And I protect myself as well, because when you're exposed to pressures of executive branch, legislative, media, economic potence, you can say, well, look, this has been since immemorable times. This has been applied like this. So this is what I call judge power. And there are atypical types of judges, and that is a judge lucky or judge puppet. Mm-hmm. So a judge who functions on the basis of the telephone justice, who completely subjugates himself or herself to someone else in the government or someone outside of the government, like economic potence and so on. And other type of atypical is the judge counterpower. So that can be reformulated, that concept. It is a situation in which the judge, it is one line from judge power. It's a judge power who understands that in the context of the collapse of the separation of power and the collapse of the constitutional system, he or she has to actually get out of the courtroom and defend the rule of law, because it's all about fidelity to the rule of law, by taking a more political stance, which is atypical for the judges. The judges are supposed to stay within the limits of their courtrooms and to decide and to perform their power. Here, this term counterpower in terms of counter to the executive power, which usually is the responsible for the backsliding of the rule of law and collapse of separation of power. And here I mean some judges, like judges in Poland, who in this context really started getting out of their courtroom and organizing rallies and marching and being very outspoken in media in order to protect themselves. And now you have the similar situation in Serbia as well. Judges Odbora struke who are very, very, well, Tudija Majić is, but I said to Cetina that I organized in 2024 a workshop where I invited a couple of judges to comment on this text. Some from Serbia, some from outside of Serbia. And Judge Majić was one of them who came and who commented on that piece of text of mine. So this is to show how judges may position themselves, and it may be, these are what Weber calls ideal models. So in the person of one judge, depending on the context, you may have two models, or three maybe, or even maybe all four, depending on the age and the circumstances, challenges, etc., etc. So this, what I take as the models, I call it figures of judges. Figures of judges. I define it in terms of their relationship with respect to their fidelity to rule of law. But you can also then use it as a model for comparison with respect to also these issues, which are relevant for our concrete context, and that is the feminist judgments. How judges relate to these type of issues, these sets of values and principles.
Sorry to say
sure.
one question.
Yeah.
In your constitution, there is one section that is dedicated to the judiciary power,
Yes.
like in the
Yes, like it is.
where there is
Yeah.
the judges are
Yeah, they're very
men,
protected.
and the impartial.
They're more protected than almost anyone else in Europe when it comes to constitution.
Okay, yes.
Yes, yes. Regarding constitution, everything's perfect.
It's written.
I can tell you. I mean, I didn't draft it, but
It's a perfect written.
it's almost. The problem is the culture of non-application of the constitution, and this is it. This is we come to the context of legal and political culture.
But your constitution was the last constitution.
Yeah,
In which year
it
was?
was adopted in 2006. It's very modern.
2006.
And
very
even
modern.
and even this section on judiciary and prosecutor's office was revised in 2022. It became even better. I mean, I'm not happy with some things, but some things have were improved in the 2006 when
And before 2006, the previous
one was from 1990, and it was also very good when it comes to 1990 after the fall of the Berlin Wall.
Okay, after the and before.
And before that, no. And before that, no, look, but you have to, this is what you have to understand. The culture is extremely important. Exactly because there is no sense of responsibility that when you adopt something, you are bound by it and you should apply it. People, they adopt text without, I mean, it's not just about Serbia, it's about many other also European, especially Eastern European countries, and across the world even more. You adopt the text, but you don't really.
We apply it when we need it.
Yes, when you consider that it's. Yeah, I mean, so there is no. It's part of. It's really a matter of political and legal culture, which. It's a matter of really more important and greater study, why and how. But the fact that for example, Italy is so rich in its culture, in other meanings of the word culture, and for example, it's now that you have mentioned it. I mean, I'm a constitutional lawyer. The studies of constitutional law started in Ferrara in 1797. I mean, this is one of the things that we quote in the constitutional textbook. In 1797, it started in Ferrara. In France, it started just a little bit later. And then in France, I followed it. When you had liberal regimes, they would introduce constitutional law as a course. In the 19th century, there was exchange of these liberal and authoritarian regimes in France. And when you would have a less liberal regime, let's say authoritarian, they would abolish the studies of constitutional law. Under the pretext that it is dangerous for the students to dwell upon the way the government functions. When you have universities like we have in Bologna for how long, you develop certain standards and certain values in certain cultures, certain culture in that respect. And the fact that France was adopting it and abolishing it, it shows how painful it may be, So, this is important, the context within which a law is applied. So it's not just important that you have a good text. It is also a question of whether you're committed to its application. Yeah. So be sure that we have very good text. And this is exactly why the question, this is a good introduction in a way into the issue of the presence of women on the bench, So what is the value of greater diversity on the bench? Symbolic. So it's first of all symbolic. The more diverse judiciary looks fairer, so that justice is not merely done, but seen to be done. This is very important. That you see, when you look at the composition of the court, that you see that kind of diversity, the gender diversity. I mean, you were just one step away from saying that. I mean, when you were explaining the importance of the reasoning, it's more about how it is reasoned than what the court actually what they decided on the merits. You can have a perfect decision on the merits, like saying that this person is wrong and this person is right. Maybe it is just like it should be, but if you didn't reason it properly, yeah, I mean, the one who lost the case will always think that the justice was not done, and the one who got the case, if he or she is fair, may also start questioning itself whether I was right or wrong. Because I mean, yeah, I mean, you hear the arguments from the other side. If you're fair enough, you can say, yeah, maybe I was wrong. You know, I don't know at the end of the day whether I was right or wrong. But this is why the reasoning is important. And this is why.
Il diritto alla motivazione della sentenza, we call it. Il diritto alla motivazione. The right to have the reason. I cannot imagine a judgment without the law.
Sentenza is the merits.
The judgment.
Yeah, the judgment itself.
I cannot. For us, it's because it's a part of our culture.
Yes. Yeah.
And we have a really good judgment written with such a deep knowledge. It's so simple.
Yes.
And because through this reasoning, you can check. You can check also if there is some
flaws in the
flaws, or if there is some implicit bias, if there is some stereotypes, if there is some mistake. No, it is democratic. It's the only way to be a democratic state.
To legitimize yourself.
Yeah. Exactly. No, sorry if I replayed that in the eastern part of Europe, there is a lack of
culture.
Legal.
Yeah.
I don't want to seem impolite.
Yeah, no, it's objectively like that. There is lack of legal culture. Yeah, for sure. Oh, I agree with you on that. Yeah. As with every profession, the judiciary should be free of discriminatory selection procedures and practices. So this is another value of diversity.
This is very interesting for every profession. It should be free of discriminatory selection procedures and practices.
Yeah.
And this is an open chapter, like about, for instance, in the cases of discrimination and gender discrimination, and the interpretation of the rule about the burden of proof. The burden of proof, what the directive say that is just you need some fact and just indizio, we call it indizio, and when there is some indizio of some discriminatory conduct, some discriminatory behavior, there is the reversal
of the burden of proof.
Of the burden of But what can happen? How you interpret?
What is indizio?
Yes, how you interpret, and maybe in this phase of interpretation of the rule, because in a way it's an open rule, it's not you say what you say in this, but if you don't clarify what you need, there is a space for the judge can pretend or from the part that apply in a discrimination case. It's a very dangerous place.
It's a very tricky, and
it's a very and in this case could be a space for the application of some discriminatory or for some stereotypes. it's even what for you is indication.
Yeah.
What is for you indication of discriminatory behavior, for instance, of the employer?
It's a very serious issue because it's on one side it's the position of the judge. On the other side, it is what is an indication for the judge and for his system of values and and what is it like for the society? Whether that person understands himself or herself that was, but for the discrimination to be established, there is no need to show an intent to discriminate. It can be, and objectively, it suffices to show that discrimination was objectively discriminatory.
Yes,
but from which perspective?
In Italy, for instance, in some judgment, the interpretation of this, need of indication was very strict.
Yeah.
And this strict interpretation impacts on the effectivity of undiscrimination law, because this rule is a rule that wants to help the weak part that has not the possibility to bring to the court the proof. This is the reason, to create the balance between the parts. But at the end of the fact, if the judge is strict in the application, in the interpretation of this indication, we didn't do anything.
You can't progress.
We can so a procedural view can impact in the effectivity of law.
Yes, for sure. For sure. I have some more ideas.
Yeah.
Yes. A more diverse branch would help to dismantle negative stereotypes and lessen the impacts of implicit bias. Okay? So the more you would have the presence of other, the more gender equality you have, the less bias there will be in interpretation. Yeah? The moving the judiciary toward the greater impartiality and fairness as a result. With greater numbers, however, outsider judges may feel free to judge differently, including in a more feminist manner. So with more women jump, with more women on the bench, it may prompt other judges to decide their cases in a feminist manner. And so, what are the features of feminist judging? Exercising an ethic of care. We were talking about the ethic of care with Professor Dragica Vojinović. Examining the gender, race, and ethnicity implications of laws and decisions. So, asking the other question, as I said, it can be about race, ethnicity, gender, and etc. Understanding and documenting how context matters. That you don't have it when you don't have someone else present in the bench who can share with you that other experience. If you don't have that presence, that you cannot profit from it. So you cannot you cannot act impartially actually and be fair in your judgment. It is for this reason, again, I will just read because the time is running out, and then maybe I will comment briefly, or if you have any questions, we can address them. A feminist judgment project is premised on the proposition that in many cases the law is at least to some extent indeterminate. They were talking extensively about it, and the judges have considerable scope to make choices between competing interpretations of law. That is the penumbra of uncertainty. In this process, a feminist consciousness or philosophy may legitimately come into play. The purpose of the feminist judgment project is to demonstrate how cases could have been written and decided differently. While women judges may not necessarily make a difference, it is more reasonable to expect feminist judgments to do so. So this is still at the level of expectation when it comes to involvement, greater involvement of women in the judicial process. Women might be taught to judge differently from their male counterparts because they bring a different experience of life to the task, because they are more likely to empathize with women litigants, because they might judge in a different voice, one which incorporates an ethic of care, or because they have greater commitments to principles of equality and gender justice. And this is what, to come to the end, this is what we will do in this course, actually. We will try to, we will have a couple of sessions where we will unpack some judgments. We will look at the facts, and we will look at some landmark judgments. We will look at the facts, and we will look at the law, and we will see how that judgment could have been written differently if the woman's question was posed. And we will also have sort of workshops or exercises where we will try to actually redraft, because the feminist judgment project is about redrafting the judgment, taking the same facts in the context of the same legal system and suggesting how that judgment would look like if it was written by someone else who had this experience or had that sensitivity or had that approach perspective in mind. Okay? Do you have maybe some questions or comments? Yes.
Is that also going to be done to write something? Or?
Yes, this will be the idea of the exam, would be to have the facts and to write a judgment. We will speak with Professor Kristic. We'll have a particular session, one session with her, where she will explain to you how the exam is going to look like. Okay. Anyone online? Do you have any questions or comments?
No, we everything clear.
Good. I'm very happy, Saiful, that you found it so. Well, if that was all, if it was clear, then I would like to say hello to you, say goodbye to you, and to wish you, of course, to attend the next classes, which we're going to have already, this week, but not with me, with Professor Kristic and I think Bojana Čučković. I mean, these two different courses which we have started now. Thank you very much, and see you at the next occasion. Yes. Sorry? Thank you. Yes, it's tonight. You know this. Srećna Nova godina.
Srećna Nova godina.
Yeah, but tonight it's Serbian.
Because tonight is Nova godina.
Yeah. Yes, thank you very much.
Thank you, Professor, and goodbye.
Thank you so much, Professor. Have a good night.
Yes, thank you. Good night. Bye-bye.
Goodbye.